and welcome to the third Global Experts Plenary at the CISDL Biennial Symposium, The Natural World, the Sustainable Development Goals, and the Law. What an excellent series of lectures we've just heard. My name is Danya Novak, and I will serve as one of your moderators for this plenary.
I'm Susan Ann Samuel, and I'm a fellowship officer with the CISDL and PhD candidate at the University of Leeds. It is my pleasure to introduce the chairs of our third Global Experts Plenary, Restoring Indigenous Rights and Health for Intergenerational Justice. Professor Maya Prabhu is lead counsel in the health program at the CISDL and assistant professor of psychiatry and faculty in the Law and Psychiatry Division at Yale University. Professor Prabhu's research interests include global health, forensic psychiatry, post-traumatic stress disorder in post-conflict situations, and issues at the nexus of health and human rights. Advocate Neshan Gunasekera is lead counsel of Peace, Justice, and Governance at Center for International Sustainable Development Law and visiting fellow at the Raoul Wallenberg Institute. Advocate Gunasekera's work has been recognized as laureate of the Raoul International Justice Award for his work in justice and inclusion, particularly in Sri Lanka through the United Nations and globally through his leadership of the Raoul International Center for Peace Education and Research. Over to you.
That would be Neshan. Is Neshan able to chime in? Let me start until Neshan can also join us. Hello, everybody, and thank you so very much for joining us today. If you're just coming online, this is our biennial symposium on the natural law, SDGs, and international law. My name is Maya Prabhu. I will be one of your chairs along with Neshan for this plenary. And it is now my pleasure to introduce our featured keynote speaker. Wayne Garmans-Williams is the founding president of the International Intertribal Trade and Investment Organization. He specializes in Aboriginal and environmental issues with expertise in corporate, commercial, and trade law. He has extensive experience in both the government and corporate sectors, focusing on promoting Indigenous trade and investment opportunities. Additionally, he serves as the CEO of the National Sixties Scoop Healing Foundation of Canada, a nonprofit registered charity, and has previously served as the chair of the Federation of Saskatchewan Indian Nations Appeal Tribunal. Wayne, the stage, or the Zoom screen, so to speak, is yours.
You're muted.
Wayne, I'm afraid we cannot hear you. Do you want to try again? And we'll just see if Tejas can also mute and unmute. 3? Nope, we're still having trouble hearing you.
Still not. Wayne, we still cannot hear you.
Oh.
Would you like to give your opening as well, Neshan, while Wayne and Tejas work?
Sure. Well, great pleasure to co-chair alongside Professor Maya Prabhu, of course, being here in the third plenary. We've had a fantastic day of sessions at the biennial symposium put together by the Center for International Sustainable Development Law on the occasion of the title, The Natural World, the Sustainable Development Goals, and the Law. I think we are in the penultimate session on the topic of intergenerational Indigenous rights, health, and intergenerational justice. And a real pleasure to connect with our wonderful speakers who are here. As our keynote attempts to connect, perhaps I could set out, Maya, if it's okay with you, introduce our panelists for later.
Sure.
Excellent.
We have a distinguished set of speakers from various parts of the world. And at the same time, I want to welcome many, many people who are connecting from all parts of the world, from the Western Hemisphere to the Eastern Hemisphere, which is quite late, as I understand. Following our keynote address, we will have a discussion on 3 key questions, and the distinguished panel will be comprised of Professor Damilola Oluwoyi, who was just announced as a Veeramantri International Justice Laureate. So warm congratulations again to Professor Oluwoyi, who is UNESCO Chair in Environmental Law and Sustainable Development at the College of Law, Hamad bin Khalifa University, and Vice Chair of the International Law Association. He's an eminent member of the Academic Advisory Group on the International Bar Association section on energy, environment, natural resources, and infrastructure law, where his books on international economic law, poverty eradication, and sustainable development have won impressive accolades. Welcome to you, Professor Oluwoyi. Then we have Dr. Rebecca Major, who is the inaugural NVD Research Chair in Northern Governance and Associate Professor at Yukon University. Dr. Major's research focuses on Northern Indigenous governance with a particular interest in the unique governance model developed by Yukon First Nations. Prior to joining Yukon University, she was an assistant professor in the departments of political science and philosophy at the University of Windsor. Professor Gerard Torres is a professor of environmental justice at the Yale School of the Environment and professor of law at Yale Law School. He is a leader in the field of environmental law, focusing on the connection between environment, agriculture, food systems, and social justice. Professor Torres' research has been influential in the emergence and evolution of environmental justice and is a leading scholar in critical race theory. He previously served as Deputy Assistant Attorney General for the Environment and Natural Resources Division of the U.S. Department of Justice during the Clinton administration. Welcome to you, Professor Torres, as well.
Wonderful. Sorry, Neshan. Go ahead.
Go ahead, Maya. Over to you now.
I was just going to toggle back. Wayne, are you online with us? Welcome.
I am indeed. Can you hear me now?
We can. Thank you.
Excellent.
Thank you for joining us. Why don't we jump right into it with your opening comments?
Thank you. I apologize for that technical glitch, but yes, to get right into it, the United Nations Sustainable Development Goals, as we all know, came into effect January 2016, and they'll continue until 2030. Now, the United Nations Development Goals are universal in the sense they're call to an action for addressing many things in sustainable economic development, ending poverty, protecting the planet, ensuring that people have an enjoyable place and prosperity, and that's all good. And one of the things I want to focus on is how Indigenous trade can play a role and tied into the United Nations Sustainable Development Goals. Now, these two goals are interconnected. Often the key in one success will involve taking issues that are commonly associated with the other. And indigenous trading nations, by their very unique experience, are best suited to help nation states meet these international sustainable development goals. Because Indigenous peoples are the original traders. Since time immemorial, we've already made the right choices of a way to improve life in a sustainable way for future generations by incorporating indigenous traditional teachings into mainstream business practices. Things like incorporating the 7th generation principle to industrial development decisions, the universal indigenous concept of that philosophy of taking, when one takes, one has to give back to the environment, the duty of making sure that the next generation and the generation after that is looked after. These are things that are part and parcel with an awful lot of indigenous cultures that can impact in a positive way indigenous ways of doing business and show to the world the best practices that the rest of the world can take a cup of knowledge from and apply. Now, indigenous concepts of healthy individual spirituality and collective community well-being are also directly connected and blended with a robust respect for the natural ecosystems. And these philosophies and systems are completely compatible with indigenous business activities and can be adapted for mainstream business. Now, I'm going to talk about the Indigenous Peoples Economic Trade and Cooperation Agreement, IPECTA. It's the very first modern international cooperation arrangement in which Indigenous peoples and their respective nation states, specifically Canada, New Zealand, Australia, China, Taipei, and soon to be the United States, negotiated a variety of issues which conduct international trade amongst the endorsed nation states and their Indigenous peoples. And these negotiations allow for the implementation of these cool concepts. And I just want to, first of all, ground the audience with the fact that this is not just a small thing. When you look at the emerging economies of Indigenous peoples, like, for example, the Maori economy in New Zealand, 70 billion in assets, trade-ready forestry, fishing, land production. Canadian economy, 50,000 Indigenous businesses, 31 billion to the gross domestic product. The Australian economy, 4.11 billion in gross domestic revenue, and 45,000 employees in the Aboriginal economy. And the United States, just three states, Oklahoma, Washington, Minnesota, $33 billion and 200,000 people in Indigenous jobs. So that's a lot of revenue, and that's a lot of practice that is responsible. Now, IPECTA is the first modern, comprehensive international Indigenous trade arrangement. It's like a memorandum of understanding. It's voluntary, it's flexible, it's cooperation-based, and it's a revolutionary instrument, not only for its content and philosophy, but also for the international Indigenous inclusiveness in its negotiations and eventual implementation and governance. Now, importantly, the United Nations Declaration of the Rights of Indigenous Peoples, informed and inspired a great deal of the IPECTA text. But what makes IPECTA different and historic and groundbreaking? Here, the magic word is inclusiveness. The four governments that came directly involved in negotiations, New Zealand, Australia, China, Taipei, and Canada, collaborated with their Indigenous peoples from the economies during the preparation and the negotiation phases, and now in the implementation phases as well, which is really empowering. And due to the good planning and aggressive consensus building by the Indigenous groups and the government negotiators, IPECTA was negotiated and signed off within 1 year. So what's inside it? Well, let's look at the core four aspects. First core aspect is the definition of Indigenous trade. This is the first time in international trade law that the phrase Indigenous trade and investment is formally agreed to between the parties and their endorsing nation states. And it's really cool because this definition is not your grandfather's definition of trade. Indigenous trade and investment, in accordance with Article 2, includes, and get a hold of this, trade and investment that is relational and aims to build long-term network exchange. 2, Indigenous laws and values, including the values of reciprocity, care, trust, respect, and generosity. 3, operating within an intergenerational framework. And finally, 4, the responsibility of Indigenous peoples to protect their lands, resources, and the spiritual interrelationship of the human and natural world, as well as the integrity of the natural systems themselves. That's a really dynamic definition, which can really go far in just not doing widgets and trade, but doing real cultural difference in the way we look at environmental stewardship. So, item number 2, the core result number 2, environmental protections. All of the parties to the arrangement acknowledge the importance and significance of international environmental agreements, and therefore have expressly included them into IPECTA. Article 3, sub E, specifically references these international trade environmental agreements to remind us all that this is the lens in which we trade in. The UN 2030 Agenda for Sustainable Development Goals, the UN Financing for Development Action Agenda, the UN Framework Convention on Climate Change, Paris Agreement, the Convention on Biological Diversity, the UN Convention on Combat Desertification, and the Convention for International Trade in Endangered Species. All of these are included in IPECTA as the lens we look through. So what's the next one? The core result, item 3, Indigenous worldview. This is important. Article 3 sub A of IPECTA states, and I quote, the participating economies recognize existing international human rights obligations are interrelated, interdependent, and mutually reinforcing, and should be considered alongside each other when advancing the rights of Indigenous peoples and their participation in international trade. So IPECTA embraces a pan-Indigenous-led philosophy of Indigenous culture, language, land, and rights that are fused to Indigenous cultural ties to the environment. And core result 4, what I call the nuts and bolts, the trade topics, trade cooperation in 22 potential Indigenous trade and business activities can be implemented. These include government procurement, capitals, markets, supply chains, Indigenous foreign trade zones, responsible business conduct, certifying Indigenous-owned businesses and Indigenous-made goods, tracing, authenticating Indigenous products and Indigenous production lines. All of this is what business means, but it's also in a lens of environmental responsible governance. So in conclusion, the final words, let's cede the floor to the World Economic Forum's 2020 Global Risk Report, which advises that Indigenous nations, through their unique experience, are best suited to help nation states meet these international environmental goals. And they write, and I quote, "Humanity relies upon Indigenous communities to be stewards of ecosystems, protecting and preserving environmental resources. Indigenous peoples comprise less than 5% of the world's population, but protect 80% of its biodiversity. Indigenous nations' unique stores of know-how and experience in environmental stewardship and economic sustainable development make Indigenous traditional knowledge best suited to helping nation states meet the international sustainable development environmental goals. IPECTA is the first major international Indigenous example of the best practice for humanity to follow." With that, I thank you.
Thank you, Wayne, for setting us up for a good conversation and a lively set of ideas. What we're going to do now is we're going to ask questions. We're going to ask each of our speakers who are online with us to respond to that, and also to think about our first question to help frame any other additional comments that they have, which is what principles and laws can secure Indigenous rights, including health and education worldwide? So Professor Torres, would you like to start with our response to the opening comments and or answering or thinking about the first question, which I've also put into the chat to assist?
First of all, I want to thank you for that opening keynote address, because it laid a lot of issues on the table, specifically the recognition, the international recognition of Indigenous people, which is complex because each nation has a different set of relations with the Indigenous people. And one of the things I think we need to think about or consider, right, is what have domestic nations done in order to situate Indigenous people to participate in things like the international agreement you just discussed. One of the critical things, I'm going to base a lot of my initial comments in the changes that have been made in the United States, and then try to tie those into international agreements and cooperation. I know I only have a couple of minutes, so I'm going to try to do it as concise as I can. Since 1971, the explicit relationship between the federal government and Native people has been transformed. And it was transformed in the direction of trying to design federal programs that enhance tribal self-governance and tribal self-determination. It exists, and this is a question I want to get to at some point, maybe in the Q&A. It exists within the structure of sovereignty that differs from country to country. So the conception of tribal sovereignty, for example, or native sovereignty in Canada is a relative but distinct from the conception of sovereignty in the United States. And even the conception of sovereignty in the United States, tribal sovereignty in the United States, continues to emerge, and it fits and starts in different ways. But a signal agreement domestically that can position tribes to participate in global, at least global commercial enterprises, is the secretarial order that was just adopted by the Secretary of the Interior and the Secretary of Agriculture, which is designed to permit the maximum tribal co-stewardship of resources that are under the control of tribal governments and the federal government. it is layered on top of additional legislative initiatives that promote cooperation between states and tribes and private owners and tribes in relationship to natural resources. The most advanced programs that have emerged relate primarily to forest resources. They are obviously going to have to include other natural resources. Fish and bison are actually, and grasslands are next on the agenda. And certainly anadromous fish necessarily tie into international agreements. So one of the things I think we can see is that the relationship of national governments to subnational formations, whether you and the amount of sovereignty that, or the kind of sovereignty that is permitted with these subnational formations, is going to set up the key set of problems, but also the key set of issues that will have to be addressed. So I have a lot more to say, but I'll just stop there and we can come back and explore each one of those points in greater detail if you'd like.
Perfect. Thank you very much, Professor Torres. I think you really reflected well on the keynote. And at this junction, may I invite Professor Damilola to reflect on the keynote message and also in your response to question number 1. Professor Damilola.
Thank you very much. And it's a great pleasure to be able to join this panel and to listen to the very, very thoughtful and inspiring keynote by our keynote speaker. I totally agree with the points made, as well as the need for us to reflect a smart mix of measures to address some of the challenges that still remain in recognizing indigenous rights in many parts of the world. As a matter of fact, in Africa and in many parts of the Middle East where I work, indigenous rights still suffer from acute denial. In Africa, the African Union, for example, has simply refused to recognize that there are indeed indigenous peoples in Africa. And that continuous denial simply means any attempt by advocates to demand for the protection of indigenous rights is met with a simple answer that all Africans are indigenous and there is no special indigenous rights. That is an argument that fails the reality of modern times. That is an argument that our working group, the UN Working Group on Business and Human Rights, has highlighted that needs to be dismantled. In our recent report on extractive sector, just transition and human rights, we have also highlighted the fact that stakeholders in business, stakeholders in all sectors must put in place measures to implement human rights due diligence in all projects, as we have recently observed that indigenous rights face a new wave of threat due to the rush for transition minerals. In many parts of the world, as the world is trying to transition to clean energy, in many indigenous lands have been confiscated. Many indigenous peoples have had to face forced relocation and displacement as governments license mineral and mining projects, especially transition minerals needed for the energy transition. Our report has called for all stakeholders to accentuate human rights due diligence aimed to protect indigenous rights. And of course, when I talk about smart mix of measures, in addition to legislative efforts aimed at ensuring human rights due diligence, there is also a need for us as stakeholders to think about other approaches, such as integrating local content and indigenous rights in investments. And the subject of local content is one that I've written extensively on, and it provides like an investment and economic approach. We've talked about the substantive legislative approach, but the smart mix of measures is basically about incorporating this right in other instruments, especially economic instruments. So there is indeed a need to integrate local content, investment in entrepreneurship that will advance indigenous knowledge and that will enable indigenous peoples to actually participate and benefit from investment activities. Yet in many countries, the issue of indigenous content, indigenous rights, as well as indigenous entrepreneurship face legal barriers, which we advocate on the need to dismantle. When we talk about the smart measures as well, I've also written extensively on the need to, when going to indigenous communities, the need to translate environmental problems into economic opportunities. And I'll give an example. I was in Iraq just a few weeks ago, and you would have seen the BBC report that talks about many poison in the sky in Iraq, with many communities and indigenous peoples facing pollution from gas flaring, which has led to a rise in environmental problems in that country and in that part of the country. And of course, one of the key things that we're advocating is the need to support gas commercialization initiatives that will aim at capturing, providing technologies to capture gas flares and use it to provide electricity to generate energy for communities that lack energy. So in addition to substantive procedural, I think there's a need for an investment approach as well, which will complement this smart mix of measures to give priority to indigenous rights in different parts of the world. And of course, I look forward to working with all stakeholders, especially in the context of my work in the Middle East and Africa, to advance this smart mix of measures. I thank you very much.
Thank you. Before we go to question 2, I thought I would invite our first 2 speakers back in for a conversation to respond to the most recent comments. Professor Torres, this might be an opportunity for you to expand on some of the points that the relationship of indigenous persons to their governments is also very context dependent, and also to relate that to the point that was just made that even the concept of indigeneity might be contested depending on region and locale. So just some ideas for you to expand upon, but we've got maybe a couple of minutes for each of you.
I apologize, there's a mower. I hope you can't hear it in the background. I will try to talk loud.
I can hear you very clearly, despite the leaf blower in the background.
Thank you for giving me the opportunity, because the issue that was raised was critical even in the negotiation of the UN declaration, right? Who gets to sit within the broad tent of indigenous people? And of course, whether you look at the Inter-American Commission or whether you look at the UN, one of the fears that nation states have is, oh my God, if you recognize indigenous people, suddenly territorial claims come into play, and it strikes terror into the hearts of nation states. But in the Inter-American Commission and the American courts, there's a relatively famous case, the Awastini case, where Nicaragua granted a timber concession to Japan, a company in Japan, and the Awastini community said, "Well, not so fast. That's our territory. You can't grant a concession to resources that are our territory." And of course, Nicaragua resisted. And they said, well, you don't have a title or a claim. And so they engaged in a long process in which the claim was articulated, described. We had anthropologists. In some ways, it's a litigation between disciplines with anthropologists and historians and whatnot. And the claim that the Nicaraguan government raised was, many indigenous people use the same territory, so how could it be yours? And what the Inter-American Commission permitted was an explanation of the different ways in which Native people use the territory. And so even though it doesn't strictly conform to the kinds of property rights that the national government tried to maintain as being utterly important, the Inter-American Commission said, no, these indigenous communities have a claim to this territory, and you've got to renegotiate the concession, and you've got to take into account the claims that these native people, indigenous people in this community have. So that's one example of how the differing regimes, the differing concepts of ownership, resource management, et cetera, come into play. And you're going to see that, I suspect. I'm thinking of the Arctic region, right? You're going to see that come into play in the Arctic region as you get nomadic people who traverse the Arctic region, irrespective of national borders, right? And that, I think, to most nation states is deeply threatening. And that threat has to be, we have to take that seriously. The other thing is that as tribal nations and as the keynote speaker noted, like creating the capacity for tribal nations to take control of some of the fundamental things like education, health, etc., is critical, but it's also going to be tied to their capacity to integrate to the extent possible, consistent with each different indigenous group, integrate into the economic system without sacrificing or jeopardizing their claim to a separate indigenous existence. So that's, in some ways, those are some of the tensions, both domestically and internationally. And with Canada, of course, the United States, and with Mexico, the United States has indigenous groups that are on both sides of the border, right? And so suddenly you get this international border that bisects the land, and we've got to figure out what exactly the claims are for these people within this kind of setting. We've done it for natural resources, right? You take water that makes up a border. We negotiate international agreements. Well, people have those claims too, and Native people have those claims too, but we haven't clearly articulated how we're going to adjudicate those claims. And so, that's just a sampling of some of the issues, but the idea, Africa presents a specific and complex set of issues for precisely the reason that was stated, which is there are no indigenous people here, right? And the UN Declaration had to confront that, right? Because everybody in Africa is indigenous, but of course that was premised upon the fear of destabilizing the colonial lines that drew the national boundaries, right? As decolonization emerged in the late 20th century. And so these struggles are just getting formulated in a way that we can grasp and wrestle with, but they're deep. They're very, very deep questions.
Right. The question of the increasingly porous border and framing will only accelerate. Wayne, did you want to respond to the opening two sets of comments?
Yeah, thank you. One of the things that both commentators, both professors referenced was the recognition of indigeneity. And as we all know, the United Nations Declaration of the Rights of Indigenous Peoples does not have a definition of what is indigenous and what is not. They deferred to each nation state to make their own definitions. Part of the problem with that, of course, is as was stated here, with the fact that we've got a problem with respect to subjective politics being played on true indigeneity. The other problem we've got is nation states that go into negotiations. I was negotiating with as a representative, indigenous representative, getting an indigenous trade chapter for the Canada-UK trade agreement, which fizzled out. And the United Kingdom came up with the position that, they don't recognize indigenous group rights. And yet, how are we supposed to negotiate an indigenous trade chapter if you don't recognize group rights? and on top of that, the United Kingdom negotiated treaties with Indigenous peoples around the world and in Canada, in my nation, up until 1933. And those are group rights they negotiated for trade with Indigenous people. So they're playing, hot and cold running water with respect to what is Indigenous, what's not, and whether or not they accept it. So that is a big issue. And it's I find the best remedy is to elevate, educate, inspire, and inform nation states to try and do better and show best practices, show examples around the world, and get them little bit by little bit to educate and want to move the yardstick further and make it in their best interest to want to show that there's traditional knowledge held by Indigenous peoples that could be shared and create jobs, create development, create prosperity, and help Indigenous peoples move from poverty to prosperity.
Thank you, Wayne. Fascinating points being highlighted. I think on this question, you can spend quite a lot of time, but in the interest of time, we're going to go into, sorry, go ahead.
One little piece I want to add is the federal government has recognized and has started to create pathways to integrate traditional knowledge into its regulatory structure, right? So that in itself is an important move. It hasn't progressed very far, right? But it is certainly taken seriously at the federal level. So you take your victories, small though they might be, wherever they are.
Thank you, Professor Torres, for that. Let's move to the next quite broad question, but real pertinent one. I've just put it onto the.
You're muted.
Suddenly muted.
Sorry. Question 2 to the panel. What can international law contribute to securing the water, food, energy nexus for highly vulnerable countries and communities? Here, Professor Damilola, may I turn to you first to reflect and share your thoughts?
Thank you very much, Neshan. The reality is that if we really want to achieve all of the SDGs, there is a need to strengthen the delivery of water, energy, and food. Without energy, there's not much we can do. We cannot cook. We cannot generate and distribute water. Without water, we cannot enjoy food, or we cannot enjoy energy. So these three areas are so intricately connected. But what we find is that in many contexts, energy projects affect water availability and affect food, especially when you start talking about displacement of Indigenous peoples from lands and from forest. So there is indeed a need to reflect that integrated and systemic approach in addressing these three issues. And these are issues you find, for example, in the Middle East, whereby efforts to address water scarcity through desalination may be indeed leading to pollution and then worsening food supply in some value chains. So there is a need to think about interlinked, holistic, and system-wide thinking on how to bring together these three sectors, realizing that the problem of climate change is even worsening scarcities of these three crucial resources. So I think international law response to climate change must be integrated, must bear in mind that any effort to combat climate change without thinking of the synergies between water, food, and energy would lead to what I often describe as maltransition or maladaptation. Maltransition simply meaning trying to achieve energy transition while creating water scarcity and food poverty, which will often result in even violation of all forms of other human rights. So I think international law has a critical role in also leading by example, breaking down the silos that still exist in the practice of international law. In my work, you find that even many of the international organizations that should come together to address these issues do not really work together. So we have a proliferation of international instruments on energy, on water, on food that are not necessarily connected. You also have a situation whereby when we're having major climate-related discussions, you hardly find energy experts there. You hardly find members of OPEC or GECF or IRENA there because they say it's a climate discussion. And so when you have these silos at the international level, it simply means we have instruments that do not really reflect the realities of indigenous communities that depend on these critical resources. So I think there is a clear need for stakeholders to have this, discussions aimed at deepening their own coherence in the way they work, which will naturally influence the way we negotiate international instruments and could bring us closer to achieving that holistic and systemic thinking that reduces fragmentation.
Thank you, Professor. May I come to you, Wayne, on this and to have your thoughts on the second question?
Sure. I think it really does come down to the importance of water as being one of the fundamental things. When we look at, for example, and I'm going to pick on the United States because I think it's a really cool example, because their water system is sort of divided between East and West. And of course, in the East, there's the riparian water system, which is basically, you can't adversely impact someone downstream, blah, blah, blah. But the really cool one is the Torrens one, where first in sight, first in right, which really potentially positively impacts indigenous people because they were there first. And so therefore their water right with respect to the use of the water is they have that primary right. And the way that indigenous peoples in the West of the United States tend to use their water rights, it's something that one could study and really examine the fact that the economic use of water and then the sharing of that water for a small fee with the other people that need it. So that it's that indigenous principle of sharing what we have. It's part yours and it's part ours. And we manage the resource together. We look after the resource together. I love that. That's really cool. And I'm sure that Professor Torres knows this much more than I do, but and has probably some really cool examples of the application of that in the West with respect to indigenous nations that use that right effectively. But the water is where it starts and ends, because you can't have an ecosystem without that, and having that right is important. The last point on the water is, I love what they're doing in New Zealand, the Maori, with respect to the river having its own legal entity and being managed by a collective Maori and government representatives. So the people speak for the water and they protect the water, because that's what's that phrase that the Maori use? I am the land is me, and that's part of the philosophy of stewarding and looking after the land and the ecosystem, because you will go back to the land and you've come from the land. So your ancestors are there and you will be there eventually. So it's that capacity to steward the resource for future generations and to respect past generations. Thanks.
Thank you, Advocate Wayne, for stressing the principle of stewardship. Professor Torres, for you to kindly respond.
Yeah, I'm going to start with the water example, though I have a couple of others. Right? I mean, one of the things that people, one of the things that's just true, right, is all the water that ever existed is here now, right? And so we've got to figure out a way to make sure that the water and the fresh water, which is a tiny percentage of the total water available in the world, is equitably shared. So to take the example of the West has a so-called prior appropriation regime. Luckily, the federal government has recognized that in the reserves, there's a reserved water right. And the reserved water right, it's governed by a priority system. The people who first use the water have priority over subsequent users. but the tribal rights are deemed to be most senior in the context of reservation claims because they date back to time immemorial, but the right is limited according to the practicable irrigable acreage on the land. So there's a technical limitation to the reserve claim, even though it is the most senior. Now we could take an example, right, of the Hopi, right, who live in a desert, right, air climate. They have successfully farmed Third Mesa for 2,000 years, right, in the desert. There are things about water use and water management that we could learn from them, just as we can learn from their transition to solar energy that they're currently underway now. But I'd like to say that in terms of international regimes, the first thing that we have to do is we have to be willing to negotiate with native organizations that are cross-national. So you can take something like the Circumpolar Inuit Council, right, which involves people in the northern climate, in the Arctic region, and the claims that they make for all of the members of that group are not tied just to resource use, but they're tied to food maintenance and sustainable food maintenance and conventional or traditional food sources, and protecting the rights to the food and the resources that they have. But there has to be a willingness to negotiate with that group, and these groups exist, in various parts of the world. The other thing that we have to be conscious of, and I'd love to get Wayne's take on this, is we have to be conscious of the way in which regulations that are not related to Native people still have an impact on Native groups. So a graduate student of mine is doing research on EU import regulations for food that is imported from globally, but specifically he's looking at Kenya and Ethiopia. And the question he's examining is, what are the effects of the EU regulations on agricultural practices at the local level, even for those farmers who are not producing for export? And what he's discovered is, in fact, that these regulations find their way all the way down, right, to the small holders. And so it's having a transformative effect on the way agriculture is done in these countries. And the EU regulations, of course, were not passed with that in mind, but they have that effect, right? And we've got to be conscious of that effect. So we have to be able to, have to be willing to negotiate with transnational groups. We have to be conscious of the way in which trade regulation affects indigenous practices. And we have to pay particular attention to, in my view, to the water resource, which is, as I like to tell my students, you can live a month without food, but you can live about 3 days without water.
Indeed. How about this? Why don't we have Wayne respond to that and also begin our final round of questions on how to reconcile pressing needs of communities with intergenerational sustainability and justice over the long term. And Damalila, I have to appreciate and thank you for bringing climate change explicitly into this conversation, and I think that'll help frame the final question. Wayne.
Yeah, thank you. The one thing that was raised here, it's a really cool concept which we all kind of are dancing around, and that's the conflict of laws. And we've got various levels, various strata of conflict of laws, which is really exciting from an academic standpoint. When we look at, for example, a tribal nation in the United States, because I think they're the easiest example to use. They have a certain element of sovereignty that's clearly established as a result of the Marshall Trilogy. So they've got a certain level of sovereignty to exercise. And what happens with respect to using IPECTA, Indigenous Peoples Economic Trade and Cooperation Arrangement, and the Maori in New Zealand? Let's assume there's an arrangement. And what happens when there's another international trade agreement that runs contrary to the IPECTA for the tribal nation to tribal nation, but the other larger international trade agreement may supersede or negatively damage the good work done, the environmental good work done between, for example, the Citizen Potawatomi Nation of Oklahoma and a Maori iwi on the coast. That kind of stuff, that's where we come in. Us good lawyers have to advocate, explore. This is the new frontier when we're dealing with Indigenous rights internationally. How do you exercise your sovereignty in conjunction with the nation state you're partnered with here in Citizen Potawatomi Nation, the United States, and the Maori, New Zealand? How does that all fit together? That's really cool. And I think I agree. The main thing is we're late to the game when it comes to international trade and international agreements. We need to get in the game. We need our tribal nations to start working with our nation state international representatives to say, okay, we're going to educate you about what indigenous rights are, Indigenous history is with the nation state, and how that impacts on how we go out into the world together, both the tribal nation and the nation state, to protect and enhance our trade rights. So kind of cool.
Daniela, would you like to expand on that, particularly maybe contrasting it with the notion that you introduced in your first words about going back to the contested or challenged issue or definition of indigeneity? And I say this because we've received several questions in the Q&A sort of noting that issue.
Thank you very much. And I think one of the key documents that I would like to highlight in the context of my work as UNESCO chair is a UNESCO Declaration on the Responsibilities of the Present Generation towards Future Generations. Of course, even though that is not a binding document, but it was adopted by more than 100 countries that are members of UNESCO. So it articulates what the present generation should be doing in the context of the future generation. And one of the key things I like that the document mentions is the duty of current generations to ensure implementation. We have talked about these issues for many years. No one is disputing the need for sustainable development. Everyone understands these issues, but where we often miss the mark is implementation. And even when you look at this issue of non-recognition of indigenous rights in Africa, especially by the African Union, it's a question of implementation. The instruments are there. Even if you look at even under domestic law, even under national constitutions, whether explicitly or impliedly, the indigenous rights are there. But when it comes to implementation, then you have the political argument that, oh, well, what are we even doing? You know, who are this? You know, what are these indigenous rights? So I think the current generation must move beyond just mere talk and political, political correctness that often lead us to a situation whereby we delay action, we delay what we should be doing. And implementation will include, taking some of the, we now have the right to clean and healthy environment. How many countries have recognized that in their domestic laws? How many countries have integrated human right due diligence, human right impact assessment when approving investments, when approving trade policies? So these are I believe that the best way that the current generation can reconcile the needs of the future generation is to start implementing international treaties and international instruments on these core issues, and to remove some of the existing barriers that make that difficult. And of course, a second point to be made is that implementation will not be possible without education and solidarity. So in places whereby that knowledge of indigenous rights is still missing, then we as international stakeholders can support education, can support awareness. Let's take every opportunity that we have to provide that collaborative support. And that's something that we are doing, providing that academic support in our network, the Association of Environmental Law Lecturers in the MENA region, trying to support awareness and education in this regard. And I hope we will support such initiatives in our work as well.
Thank you, Gerald. I'll give you 30 seconds to have the final word on this.
Well, I was going to say one of the, it's not just New Zealand and Ecuador that have recognized kind of rights of nature. A couple of tribes in the United States, the White Earth in Minnesota, Penobscot in Maine, have made the some natural features citizens of the tribe. Now, the American legal system has no way to metabolize that. Let me put it that way. Right, but it does put the issue on the table, and I'll stop there. That's my 30 seconds. I have, of course, more to say.
Beautiful.
Thank you very much, Professor Torres. Go ahead, Maya.
No, I was just thanking all the speakers for that, and we realize it's a round table, so never enough time to amplify everything, but I think it laid out a map for our discussions in Q&A. Neshan, do you want to introduce our final speaker, and then that will allow us then to have some interventions and then move to the audience?
Perfect. Thank you, Maya. Yes, we've have a distinguished expert with closing remarks. I have the great pleasure of introducing Professor Honorable Justice Marcel Szabo, who is a Justice of the Constitutional Court of Hungary and a full professor at the Pázmány Péter Catholic University, where he heads the Department of European Law. He holds a PhD from the Pázmány Péter Catholic University and has extensive academic experience in European and international law. Professor Szabo has also served as ombudsperson for future generations in Hungary, advocating for sustainable development and intergenerational equity. He has previously served in roles as a representative of the Hungarian government at the International Court of Justice and as a member of the Permanent Court of Arbitration at The Hague. Justice Marcel Szabo, over to you for closing remarks. Justice Szabo, you are muted.
Dear colleagues, dear friends, it's a great honor and privilege to be present at this roundtable, and I think we have learned a lot today. Let me take just an elemental distinction between two orientations. How can we speak about the rights of indigenous people? And one is an expectation to be fair to indigenous people as a group, which meaning that those who are more powerful, more capable to use the resources of the states, they should not bring indigenous people to a situation where their right to food, to water, to energy is unfairly deprived. And we know a lot of examples then when big companies like Coca-Cola are battling water in places of the world where there is a scarcity of water, and they are bringing back to the consumers of the world, depriving these communities from adequate food resources. But in a way, we always understand indigenous people as people living some sort of a tribal life, missing appropriate kind of modern knowledge of technology, but on the other hand, having the traditional way of knowledge in many fields, especially medicines, from which we can learn from. But I think that is just one component of how we should look at indigenous people. And there is a core component in which indigenous people are not a distinct group from us in a certain way. And that is that what they basically want, they are a community who are living at a given territory for hundreds of years, and they would like to maintain the cultural identity, their very specific knowledge, their very specific practices, and they would like to pass it on to future generations knowing that the resources on which that community is living is not deprived from them. And I think if you take the definition in a very broad sense, I think we can realize that not only Aboriginal groups in the vast desert of Australia can be regarded as a community with indigenous rights, but think of other communities in a similar situation. Think of people living for hundreds of years in a given country. When we are speaking about indigenous people, we never think of Siberia. Think of how many little nation is living there who have been oppressed by the regime of the Russian Tsar, and they still want to maintain their traditional culture. But even think of situations like the Romans living in Switzerland, a group with a long-standing culture without properly building in Switzerland. And if you put it in a big perspective, I think the whole community, the whole world has to be afraid that giant multinational organizations and companies can deprive us in the same way from our traditional culture or traditional roots to the community in which we are living, from the traditional knowledge which was self-evident for hundreds of years. Let me just make two critical remarks as regards the European Union. Let's speak about harvest. It was for hundreds of years, it was self-evident that not the last grain has to be collected, but something has to be left for the poor and for the birds. And not the last piece should be removed from the forest, but there should be trees and resources left for those that are in need. Think of agricultural land as part of the chapter on capital in the European Union's legislation, meaning it's part of the chapter on capital, so with the incentive of allowing money to grow and earn more. Think of European agriculture policy, which gives financial incentives so that more and more territories are utilized because there is a financial compensation for environmental agricultural damage. And of course, lands that should be left uncultivated are now cultivated against the rational use of natural resources and biodiversity. So what I want to say with this, that we should hold the hands of indigenous people, but we shouldn't regard them as a faraway distinct group who will be good, are so upon mercy we are going to lift up. We are having, in many ways, the same problems, the same matters. And we wrote a book with Marika Krodany-Zeger and Alexander Harrington. And in this book, we are trying to make a stand that it's very important for the sake of future generations that there is some emotional linkage to the current generation vis-a-vis the future one. We should have our cultural roots maintained, and we should have our togetherness and collectiveness maintained so that we can believe that it is worth to leave the planet or land for future generations. It is in the interest of all indigenous people's rights, but all the rest of humanity.
Professor Sabo, thank you for that. I wish we could expand more. We have the time to think through more the emotional investments that we all have in our cultural and environmental heritage. But to be continued, I'm going to invite one of our interveners, Eva Wu, who is one of our researchers and the numerous recipient of many young leadership awards. Eva, over to you. I know you had thoughts to share and to ask.
Thank you so much, Maya, and thank you to all the panelists. I really appreciate all the comments today. It was really a fascinating discussion and still more to come. One of the thoughts that I was having as you folks were discussing is this idea of sovereignty that Wayne specifically mentioned, but also the development and what we can do for future generations. Especially to Professor Szavo's comment on Siberian and Northeastern cultures, which particularly touch my own heartstrings. There's this sort of fundamental ontological disconnect between what a lot of Indigenous cultures strive for in terms of the ontological basis of that, and also what we operate in terms of the dominating capitalistic markets that exist in what we see as the predominant economy. Perhaps one thing I'd really be interested to hear from all of you folks is sort of how do we bridge that gap, especially as many people on the call today might not necessarily work directly in relation to this kind of work. How can we make sure that as participants in the legal field, either as students, like many of us helping organize today, or as legal practitioners or professors, how can we all participate in this?
Ambitious question, Eve. All right, Professor Torres.
Where to begin? I mean, one of the okay, I'm going to approach it in two ways. Okay, one, I'm going to approach it as a practitioner, as a lawyer, right? The other way I'm going to approach it is from the perspective of competing ideas of sovereignty that are currently in play, right? So that you know, the peculiarly Canadian version of sovereignty that they apply to Native people is in my view quite problematic, because it doesn't completely give agency to Native communities to act as if they were in fact the agents for their own future. So, but I recognize once you raise the question of sovereignty, the people's backs go up. People worry about destabilizing institutions that have of long standing. But it's a critical discussion to have when you're litigating it. Here I'm speaking primarily or exclusively of the American context, right? When you're litigating it in the domestic context, what's critical in order to succeed is to put the question of sovereignty over here and to make the arguments as non-problematic in terms of sovereign claims as you can, right? That's in litigation. In legislation, what you want to do is you want to create the pathways for Native groups to be able to exercise all of those powers that might be associated with sovereignty without actually having to make that claim. The key distinction in American law, in the United States law, right, is whether the power that tribes are exercising is inherent to them or whether it's delegated to it by the federal government. And what you want to do is you want to reduce the category of delegated powers to the extent that you can, and increase the idea that there are inherent powers that are reserved to the people. I think it was Hume that said, right, that modern history began, right, when Columbus disembarked from his return voyage to the Americas. And that's because it put everything back into play, right? We're still in that moment.
Beautiful. Actually, Wayne, do you want to respond to that? And then we'll broaden the lens to Daniel's comments.
Yeah, sure. The general question was dealing with capitalistic markets versus indigenous traditional knowledge and how to fuse, how to relate the two from as a practitioner standpoint. And one of the things that I personally had happen to me, I was senior counsel for the Sierra Legal Defense Fund, now called Eagle Justice. We were heading up a new organization called Eagle, Environmental and Aboriginal Guardianship through Law and Education, which basically did pro bono work for First Nations in Canada. If there was an environmental issue and an Aboriginal right, we would go in and we'd litigate. So one of the first things that I learned, because I was a litigator from way back when, and I thought I'd just go in there and get an affidavit or two, and I know the test to get the injunction, bing, bang, bong, I'll be back in time for lunch. Well, that wasn't the case with respect to the First Nation that wanted to work with us. I was told that the elders would not be available to get the traditional knowledge from them until they got to know me and I got to know the entire First Nation. So I checked it with my boss, the chief. I was there for a week and I listened to the elders and I appreciated the history, the stories, the language, the land. And only when I had a full understanding of the nation did the elders decide that they would impart the most important and salient piece of information I needed for my case to save this species in their traditional territory. And so, in short, go on the land with permission from the tribal nation, listen to the elders, follow them on their trap lines when they go fishing, hunting, trapping, harvesting, and listen to the stories, because the stories are the history, and connect that to the people. And it's all about language, land, and the culture. And having as a litigator, as a practitioner, having a full understanding of that allows you to better represent your client on that one particular interest. So that's my advice.
Thank you. Okay, Malona, do you want to end as we widen to a global lens?
Thank you very much. I think the fine points made by Wayne, as well as Gerald, widen it already. So to further widen it, I will just add the role of businesses, given my work, with the UN Working Group on Business and Human Rights. Businesses have a lot of economic leverage that they can actually use to enable, to get government to do what they should do. So for example, we talked about the reluctance of the African Union and other stakeholders not recognizing indigenous rights. And I think businesses can use their leverage in saying, we will not invest in country A or country B without protection for indigenous rights, knowing that whenever there is such concern and complaint erupts off on their reputation, it even affects their profitability. So we're trying to, get businesses and all key stakeholders to use their leverage to promote indigenous rights, as well as to support education awareness in this area. And I think if we can do that, the economic power that many of the businesses have, if they can use it in the positive way, then we will be making some progress.
Thank you very much for that. Neshan?
Yes, thank you, Maya. As we were going on with this wonderful discussion, we had Danya and Susan monitor what was going on online. Danya and Susan, may I now invite you to possibly check one question each to our eminent panelists, please. Danya, Susan?
Yes, thank you. Hussein Batar from Dublin, Rosaline Awino from Kenya, and Elizabeth Cardona from Guatemala have all commented on Indigenous people's rights with regard to the impact of climate change. These questions encompass inquiry on whether there are any actions or laws which protect Indigenous populations' agriculture from climate change, and more generally on securing the water, food, energy nexus for highly vulnerable countries and communities.
Further, there are questions from Professor Gearing from UK, Moran Katai from Zambia with respect to ambition. Firstly, on trade, as to whether an ambitious Canada-UK trade agreement promote indigenous trade. And second, on the ambition to scale up the right to water for indigenous people. Any thoughts, please?
Thank you, Danya and Susan. May I invite
I would
Professor
yield
Torres?
to
Go
Wayne to
ahead.
talk about the trade.
Yes. Yeah.
Go ahead, Professor Torres.
Well, I was, I mean, one of the issues, of course, is the recognition that climate change is in fact driving a lot of the changes to kind of traditional practices. Central America has been particularly hard hit, but you know, it's, and Maya's heard me say this, so I apologize, Maya, but you know, if you look just at the United States, right, the two communities that have had to be relocated completely are both Native communities, because the land has been subject to sea level rise, and taking into account the impact of climate change on Native people is fundamentally important, because in a lot of cases, in my view, the Native communities are like the first warning device, right? It's the tripwire that tells us that we need to act. But if they're devalued within their nation state, then that warning is apt to go unheeded. And so the recognition of Native people it can be thought of as both important for kind of basic normative positions regarding equality under law, but it can also be thought of as very selfishly, which is, if we ignore this, we're ignoring the hazard to the rest of us. And I think that people need to pay attention to that. I'm not sure that answered the question, but that's what.
Thank you. No, there were many questions embedded. So Wayne, then Damalila, and Professor Justice Sabo, you'll get the final word.
Yeah, in short, to answer that question, look to the United Nations Declaration of the Rights of Indigenous Peoples first as a touchstone. There are provisions in there that provide the Indigenous peoples have the right to clean water and environmental protections. And part of that, of course, is Article 10 and Article 11, which allow for the right of practice of their culture and the expression of their language, the living on their land. As well as Article 20, which allows for the ability to determine their own means of trade and commerce, which means their own practices of agricultural environmental stewardship. So all of that is a starting touchstone, using UNDRIP as a base of discussion and then branching out from there.
Thank you. Damalila?
Yes, I totally agree. And I think what could be added to that is the need to also then strengthen domestic implementation. If there are gaps in domestic laws that weaken the implementation of indigenous rights, then there is a need for reforms. And I mentioned this in the context of the fact that countries are now beginning to adopt climate change legislation, where we have Nigeria, for example, with its Climate Change Act of 2021, but you still see that even in this emerging legislation, there is really no mention of indigenous rights, and in some cases, there is no mention of the need for free, prior, informed consent, and the need for human rights due diligence. Back in the days when I was doing research as a student, I thought the problem was that the laws were archaic, and that they needed to be updated. But seeing this same pattern being repeated in even new legislation coming out in 2023, 2024, then worries me that the rights of future generations may not indeed be making their way into new legislation. So I think there is a need to look at reforms. There is a need to empower and educate those coming up with domestic legislation to be able to integrate some of these well-elaborated concepts, as mentioned in UNDRIP, to put them back in domestic legislation.
Thank you, Professor Justice Sabo. Final words to you, and feel free to leave us on an optimistic note if you can.
That's a challenging question, but I will try. I think water, I would like to return back for a second to water. Water is a very, very important scarcity for all indigenous communities and just as other vulnerable and disenfranchised communities. And it's a very interesting thing that it is in itself an intergenerational and an intergenerational matter. We had a situation when a Roma community was deprived of public wheels because at the summer heat of 40 Celsius because they didn't pay a certain tax. And the Ombudsman's office declared that it is they have to immediately open the wheels for the community because nobody can be deprived of the appropriate amount of water. At the same time, it's not only an intergenerational matter, but also an intergenerational matter. We have to be careful for the generations to come. And when I was preparing for today's meeting, I was looking for different dictionaries summary of what indigenous is. And in one of the dictionaries, I have seen an example sentence, and the sentence was nothing was left for the indigenous people. Well, it's not a very positive sentence. So starting with this point, I think we can hope that this enthusiastic community that I had the privilege to meet today is doing very well in all their respective fields and specific expertise in order to help a better pathway than the dictionary was forecasting.
Thank you. And I think Neshan and I share your thoughts. That first attention paid is the beginning of finding a solution, but we also appreciate this enthusiasm shared by our moderators, our CISDL speakers who've worked tremendously behind the scenes to arrange for this lineup of brilliant speakers. To all of you who've participated, thank you so much. Gerald, Wayne, Dimalola, Justice Szabo, thank you. We should resume again and meet again to build on these insights. But I thank you all for capping off what I think has been an extraordinary day. So I will leave you all there. Thank you for your time. And perhaps you will be able to see many of you, including the speakers, if you have the energy, for our closing round table, which will be starting in a couple of minutes. Thank you all.
Thank you.
Warmest of thanks to all of you. It was a truly fascinating and enriching discussion, and we look forward also especially to making the videos available to the thousands who have signed up to see them. You're an inspiration to so many of the current and future law and policy leaders that have joined us online and that are going to be watching you over the coming weeks. Thank you.
Thank you.